Welcome to the NC Injury Rights Podcast.
Welcome back to the North Carolina Injury Rights Podcast with Mehta and Jason McConnell, where we break down workers' compensation issues for North Carolina workers injured on the job. Vero and Jason are co-founders of Mehta McConnell, PLLC, a Charlotte-based law firm focused on representing injured workers across the state. Both began their careers representing employers and insurance companies before shifting their focus to helping injured workers understand how the system actually works. I'm Evan Mack, and today we're talking about permanent impairment ratings, what they mean in a workers' compensation case, and how they can affect benefits settlement decisions. Gentlemen, welcome back.
Hello, Evan. Thanks for having us again.
Good to see you guys. Vero, let me start with you. What is a permanent impairment rating in North Carolina workers' compensation case, and what stage of the case does it usually come into play?
A permanent partial impairment rating is usually assigned by an injured worker's treating doctor towards the end of their treatment. At the end of an injured worker's treatment, the treating medical provider will say you are at maximum medical improvement. And what maximum medical improvement means is that the injured worker may not be 100%. Okay, they may not have made 100% recovery from their injury. They may still have ongoing medical problems, but the doctor's saying, I have provided you the medically appropriate care for your type of injury, and you are at the end of your healing period. Your condition is pretty much plateaued. This is as good as it's going to get. So, you've injured your arm. I've done the surgery or the conservative treatment. We've done the physical therapy. You are now as good as you're going to get. You may still have ongoing impairment for that arm, and that is what the permanent partial impairment rating reflects. So a doctor will say you have a 5% permanent partial impairment rating. That reflects the severity of your injury. And even after all the treatment, still the ongoing limitations that you suffer, and therefore I'm assigning you, dear injured worker, a 5% impairment rating.
Jason, who determines an impairment rating? What medical guidelines are typically used to calculate it?
So the authorized treating physician chosen by the insurance company assigns the permanent partial impairment rating at the end of the healing period when the individual has reached maximum medical improvement. They're the doctor that's most familiar with the treatment that you had, the nature of your condition, the improvements, if any, that you've made along the way. So they're the ones that assign the first rating. And I say first rating because the statute does allow for all workers who receive a permanent partial impairment rating to undergo a second opinion on that rating with the physician that they choose. But the guidelines that the physicians use when assigning permanent partial impairment ratings are actually published by the North Carolina Industrial Commission. They're largely based on the American Medical Association's guidelines for permanency, but they do, there are distinctions and differences between the two. But those guidelines are published on the North Carolina Industrial Commission's website, and anyone can go to their website and download a copy of that to kind of get an idea of what they're looking at in terms of a rating for an injured body part based upon, the treatment that they've had, the amount of impairment they're continuing to suffer, and things like that.
So, Vero, how does an impairment rating directly affect the benefits an injured worker may receive?
I mean, that's a good question. It's a very nuanced question. What I would tell an injured worker is when you are getting to the point, when you're getting at maximum medical improvement, the point where you're about to be assigned a permanent partial impairment rating, it is a very good idea to consult an experienced workers' compensation attorney in North Carolina. In a lot of our cases, the injured worker is never paid for the permanent partial impairment rating they are assigned by a doctor, because it often makes sense for the injured worker to continue receiving ongoing temporary total disability benefits, which is their wage loss benefits. Okay. The Workers' Compensation Act says that the injured worker has to elect their remedy, and they have the right to elect the most beneficial remedy for them. An experienced workers' compensation attorney can help an injured worker make that decision as to which remedy makes the most sense for the injured worker, whether it's to continue receiving wage loss benefits, whether it is to get paid for the permanent partial disability benefits, or there's possible third or fourth options where maybe the injured worker shouldn't even be receiving a rating yet. Maybe they aren't even at maximum medical improvement, and maybe a experienced workers' compensation attorney can help them get more treatment, get a second opinion, because there's a chance that a doctor is rushing them to MMI, the maximum medical improvement, without giving the injured worker all the treatment they need. So definitely consult a workers' compensation attorney when you're getting to that stage of your case where you believe a rating is going to be assigned.
Jason, what's the difference between temporary disability benefits and benefits tied to a permanent impairment rating, and how does that, a worker, which one applies?
So when we talk about temporary disability benefits, we're talking usually about temporary total disability benefits under Section 9729 of our Workers' Compensation Act. And those are what the layperson would generally call wage replacement compensation. So that you're getting paid for the time that you're out of work. That's the amount you get paid for temporary total disability benefits is based upon the calculation of your average weekly wage. You're paid 66 2/3% of your average weekly wage in North Carolina. And the reason that you're paid less than your full average weekly wage is because all workers' compensation benefits in North Carolina are tax-free. So that other third is basically taking into account what you would normally pay in federal and state and local taxes. So you don't receive that part because you're no longer paying those taxes. The money or the compensation or award you receive after you reach maximum medical improvement is based upon the impairment rating assigned. The Workers' Compensation Act has a schedule of injuries contained at 9731, Section 9731 of our Act. Each body part is listed in a certain number of weeks for the total loss of that particular body part are assigned in the statute. And to arrive at your permanent partial impairment award, you simply multiply the amount of rate of impairment assigned by your authorized treating physician to the number of weeks for that particular body part to arrive at the number of weeks of compensation you're entitled to for permanent partial impairment. For example, if an individual has suffered a back injury, has undergone treatment, which may have included a surgical procedure, and is ultimately assigned a 10% partial impairment rating to the back. Under our statute, the back is worth 300 weeks of compensation for total loss of use of your back. So you'd multiply 300 by 10% for 30 weeks, multiply that by your compensation rate, and that's your award.
So, Vero, if an injured worker believes their impairment rating is too low, what options exist to challenge or maybe dispute that rating?
As Jason said earlier, an injured worker has the right to receive a second opinion on their rating with the doctor of their choice. Both of us are board certified workers' compensation specialists in North Carolina. Our firm has relationships with doctors across the state. We can help an injured worker present to a doctor who is going to give them, or who we are at least confident is going to give them, a more favorable permanent partial impairment rating. So yes, it is important for an injured worker to know that they still have rights even after that first rating has been assigned, especially if they're dissatisfied with that first rating.
All this stuff. So Jason, how do insurance company rely on impairment ratings when evaluating or negotiating workers' compensation settlements?
Well, they're going to run that calculation that I just talked about before and find out kind of what they're going to be required to pay. You can pay a rating two different ways in North Carolina, basically. The first way is via a Form 26A agreement, and that is an agreement for compensation of permanent partial impairment. It only compensates the injured worker for the permanent partial impairment they've suffered as a result of their work-related accident. The other way that we typically resolve claims in North Carolina, even those including permanent partial impairment, is via a compromise settlement agreement or a clincher agreement. And that not only takes into account the permanent partial impairment award, but also the amount of future medical treatment that the individual may be entitled to under the Workers' Compensation Act. So the ability to look at resolution types, ways to resolve your claim, either just for the payment of the rating or via a clincher agreement, can factor into how you want to proceed once you have reached maximum medical improvement and been assigned a permanent partial impairment rating.
So Vero, is a higher impairment rating always better, or are there situations where other benefit considerations matter more than the rating itself?
The severity of an injured worker's injury. Okay, if nothing else, just kind of psychologically, it sends a message, that the treating doctor is giving a high rating because they're acknowledging that this was a serious work injury. That being said, as I stated earlier in one of my responses, this is a very complex issue. Oftentimes, other benefits, such as wage loss benefits, what's known as temporary total disability benefits, are a more beneficial remedy for the injured worker. So, uh, it is important that other issues are addressed at that appointment where the doctor is assigned a permanent partial impairment rating. And one of those issues is it's important to address whether an injured worker has permanent work restrictions, because if they have these work restrictions, then oftentimes it may make sense for them to keep receiving ongoing temporary total disability benefits instead of receiving payment for a permanent partial impairment rating.
So, Jason, how does an injured worker's ability or inability to work, factor into impairment ratings and overall benefit decisions?
So, as Viral alluded to earlier, at the time an employee reaches maximum medical improvement and is assigned a permanent partial impairment rating, there's sort of a diverging of options at that point. If the worker is assigned permanent work restrictions that can't be accommodated by their employer, or outside of the requirements of their pre-injury job, and they're required to go out and find other employment, the law allows them to continue to receive weekly temporary total disability benefits until either the employee finds a suitable job within his restrictions, or the employer has ways to assist the employee with job searches as well. They can assign vocational rehabilitation, which is a topic we'll probably discuss at some point in the future, to help the employee find a position of suitable employment. But what's important to know is that the permanent partial impairment rating corresponds to a number of weeks of compensation that you're entitled to once you reach maximum medical improvement. If you also have permanent work restrictions that do not allow you to return to work, you continue to receive your weekly benefits, but each week that you continue to receive temporary total disability benefits upon past the point of maximum medical improvement, you're diminishing the amount of permanent partial impairment award you're entitled to. So an easy way to think of it is, if you have permanent work restrictions assigned that don't allow you to go back to work with your pre-injury employer, and you're assigned that 10% rating to the back we talked about earlier for 30 weeks of compensation, you can continue to receive, if let's say you find another job 15 weeks after you reach maximum medical improvement, you will have continued to receive 15 weeks of temporary total disability compensation under the Act until you return to work. You deduct that 15 weeks from the 30 weeks of compensation you're owed for permanent partial impairment, and then you receive an award for the additional 15 weeks. If your disability period runs beyond that 30-week period, you've exhausted your right to permanent partial impairment award. But you do continue to receive weekly compensation until you return to suitable employment for a period of up to 500 weeks in cases where the individual is not permanently and totally disabled, or at the 425-week period if you remain permanently and totally disabled, and that's defined under our statute as well. You can apply for extended benefits beyond that 500-week period. So there is a big impact on the value of your claim and the compensation you're entitled to, depending upon whether or not you're assigned permanent work restrictions at the point of maximum medical improvement.
And Vil, to wrap things up, Before accepting an impairment rating or a settlement offer, what issues should injured workers make sure they fully understand so they don't unintentionally give up benefits?
Good question, Evan. Again, this is an important part in a case to talk to an experienced workers' compensation lawyer. If you, as an injured worker, accept payment for a rating, you will sign a industrial commission form called a Form 26A, and it has a lot of legal language at the end of it that warns the injured worker that this is going to start a statute of limitations on your right to receive future medical treatment, as well as change of condition and other sorts of issues. So you really want to talk to a lawyer to make sure that it makes sense to accept payment for that rating. Obviously, if you settle your case completely, your case is forever closed. So that's again a very important decision to make in a workers' compensation case that you want to talk to a lawyer about. And then, like we talked about, even if you take that rating, um, you are then electing that as your most beneficial remedy and potentially waiving your rights to get wage loss benefits. So these are very complex decisions that it definitely is in an injured worker's best interest to call an experienced North Carolina workers' compensation attorney before signing any document that an insurance company sends them or that a defense lawyer tries to get them to sign.
Good stuff. Good information, gentlemen. Thank you so much for your time.
Thanks, Evan.
All right, fellas. And also, that wraps up today's episode of the North Carolina Injury Rights Podcast. If you have questions about permanent impairment ratings or how they may affect your workers' compensation benefits in North Carolina, you could visit MehtaMcConnell.com to find more information and resources from an attorney, Vero, Mehta, and Jason McConnell. Thanks for listening, and don't forget to subscribe, leave a review, and share this episode with someone who might need it. We appreciate your time, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.